everyone. I'm attorney Donna Becker, and this is Take It to the Board, where we speak condo and HOA. Having represented community associations for more than 2 decades, I feel very comfortable with most of the questions my boards throw at me, but one area where I pull in an outside expert is for employment law issues. Jamie Dokovna is a shareholder at the Becker law firm. She focuses her practice on business litigation with an emphasis on employment law. She has extensive experience representing employers in various aspects of employment law and litigation, including litigating claims for wrongful termination, harassment, discrimination, retaliation, covenants not to compete, claims brought under Title VII, claims brought under the Americans with Disabilities Act, the ADA, including claims brought under Title III of the ADA, where business owners are often sued for alleged non-compliant properties, the Family Medical Leave Act, or FMLA, the Age Discrimination in Employment Act, Florida Civil Rights Act, claims brought under the Fair Labor Standards Act, FLSA, for overtime and other wage violations, and claims based on housing discrimination. Jamie has handled claims with the Equal Employment Opportunity Commission, also known as the EEOC, the Florida Commission on Human Relations, the Florida Division of Administrative Hearings, the Florida Department of Economic Opportunity, the U.S. Department of Housing and Urban Development, which many of you may know as HUD, and claims brought on the county level from the investigation stage through trial. Jamie, welcome to Take It to the Board.
Hi, thanks, Donna. I'm happy to be here. This is an exciting time to talk to you.
Well, we are excited to have you on. And as I said at the opening, representing community associations touches on a lot of different areas of the law. But one area where I think it requires a specialist as opposed to a generalist is employment law. Since this is a specialty area, I want to know, how did you come to practice in this area of law? And I'm thinking, do you have a juicy story where some employer in your past did you wrong and you vowed to become a labor lawyer?
I wish I had a juicy story because it would make this so much more interesting. And I, like a lot of lawyers, just fell into the practice. I was working at a firm, and the partner that I was working with was interested in practicing employment law. And so he and I kind of learned it together, and I loved it. And it was just one of those areas of the law that I gravitated to because a lot of people are employees. A lot of people are employers. It's relatable. It's real life. And I found that I could hone a lot of my good skills in that area, like being personal and talking to people and trying to understand and figure out issues and work with them to work through those problems.
I'm wondering if you get hit up a lot at cocktail parties or maybe at Thanksgiving with employment questions.
I do all the time. And people say, I don't want to bother you, but I have this question, or I have a friend that wanted me to ask you, or I don't want to take up a lot of your time, but yeah, so people always want to ask questions that are employment related, and it's fine.
Well, now you'll be able to just point them to this podcast episode.
I know. It'd be like an encyclopedia.
So I'm sure some of the confusion that I hear a lot from my clients is the difference between what's an employee and what's an independent contractor. And I know a lot of people get this wrong, and there are consequences if you're paying somebody as an independent contractor and not an employee. So maybe you can just start out by explaining the difference between these two individuals, an employee versus an independent contractor.
Yeah, it's one of the common misconceptions in my world. A lot of times I will hear from clients and they will tell me that they think this person's an independent contractor. And when I start talking to them, the person's there every day of the week. They work 40 hours for this individual. They set their pay, they provide them all their tools, etc. And at the end of it, I'm thinking, why do you think this person is an independent contractor? What is the difference with this person and any of your other employees? Because a lot of times they have employees, but for some reason they make a distinction in their mind. But there are legal tests to determine whether or not an individual is an independent contractor versus an employee. Policies regarding how we classify may change a little bit based on who is in the Oval Office. But generally speaking, the tests that courts have developed over time look at various things to determine whether or not a person fits more in one category than the other. So, for example, they look at the level of control. do you get to decide your own schedule or someone deciding it for you? There have been courts that look at whether or not there's economic dependence. So if you are primarily reliant on this one corporation to pay all of your bills, it's probably more likely than not that you're an employee as opposed to an independent contractor. Whether or not you provide your own tools or whether somebody provides those things for you, the permanency of the relationship. So one factor is not more determinative than the other. However, over time, two of the more prominent ones, I would say, are definitely the degree of control and the dependence, the economic dependence on the entity or individual that is doing the employing.
Yeah, I agree, Jamie. I mean, when I think about independent contractors, sometimes I use this analogy like a landscaper. You don't know what day of the week they're going to show up. They bring their own tools. They're not your employee, as opposed to an individual that an association may hire to do the landscaping in-house. You're providing the tools. You expect this individual to be there, let's say 3 days a week during certain hours. Is that pretty much the litmus, one of the basic criteria?
I mean, listen, I think it's a very practical test. I mean, from my perspective, I always say, if you have an independent contractor, a true independent contractor, you're really a business doing business with another business. And I know that's a lot of business, but if, for example, you hire a landscaping company and they come to you whatever day they feel like they're going to be able to come to your neighborhood, they provide the staff, they provide the tools and all of those other things, you're doing business with another business. If you hire an individual who's going to be, your groundskeeper, who's there every day, Monday through Friday, 5 days a week, and that person is completely economically dependent on you, you provide the tools and all those other things, even though you call this person a separate business and it may be, John's landscaping company, that person probably is your employee, even though you're trying to fit it into that other set of criteria to make it look more like an independent contractor.
And I've seen that happen where it's somebody who's actually incorporated. So the employee has set up a corporation, the association's paying that corporate entity, but the function really is that of an employee. Now, what if an association gets this wrong?
Well, that's the thing. There are consequences if you get it wrong. And there can be a lot of consequences. I mean, usually the one we see the most often is with the IRS, because the person has not been classified as an employee. Employees are taxed differently than independent contractors. They would get a W-2 as opposed to a 1099. So that's, one of the glaring obvious ones. But there could also be issues with, workers' compensation. If the person gets injured on the job and you don't carry workers' comp insurance because you've improperly classified your employees, there could be issues with unemployment. So, for example, you end the relationship and the person claims unemployment and you say, well, what do you mean? I never employed this individual in the first place. And then also issues with the FLSA. There could be misclassification issues. A person could get paid overtime, or I should say should have been paid overtime and they weren't. So those are the kinds of pitfalls that can be real problems and can really affect you financially if you've made that mistake.
So it sounds like there's consequences legally and financially on both ends. If there's a misclassification here, there's consequences to the employee or the independent contractor, and there's consequences to the employer. You touched on wage and overtime. A lot of employers get that wrong as well, as to whether or not their employee needs to clock in and clock out, or this person is salaried, and we call that exempt.
Yeah. So the major categories that you're looking at there are exempt and non-exempt. The FLSA, the Fair Labor Standards Act, is a law which is really misunderstood. It's a law that is super antiquated. So you can imagine a law that was enacted in 1929 and meant to apply to we're on a podcast. I mean, in 1929, they would look at you like you're crazy if you told them, I'm going to be on a podcast and I'm going to be talking to another individual over the internet.
And this is the law that we're now relying on still to this day.
Exactly. And how it's been interpreted over time. And so when you have an individual that is exempt from the law, it means exactly what it says. The law does not apply to you. So if you're exempt, it doesn't apply to you. You don't really have to look at its mandates, et cetera, to determine whether or not any of the mandates apply. If you're not exempt, which is a very large segment of the population. And there's a lot of exemptions that exist incidentally. And I think that's probably in part why it's so difficult to understand. And that's where a lot get into problems. I mean, the record keeping, sometimes I don't see a whole lot of record keeping violations. Sometimes it happens. That's just sloppiness in my world. It can be very easily fixed. But the non-exempt versus exempt part is a little more difficult because you have to do a legal analysis to figure out which is which. And if the person isn't exempt from the law, well, what does that mean? Typically that means if the person works more than 40 hours in a work week, that individual would be entitled to time and a half.
This also varies, Jamie, by state, because I know California has a much higher overtime requirement than, let's say, a state like the one we're sitting in, which is Florida. Is that correct?
Yeah. So, interesting that you say that. I mean, states have lots of laws that are their own. So we have federal, which applies to all 50. It doesn't matter where you are, those laws apply. States, even municipalities, have their own laws. So wherever you are, you obviously have to comply and you have to look at all three. It's not just one or the other. Florida has made it easy for people like me because Florida doesn't have a ton of its own state laws on the books. And a lot of the state laws mimic the federal. So there's a distinction without a difference when it comes to the analysis. There are a lot of laws on the books that are a lot stricter than what you would see in federal land.
Well, let's talk about that. So an association, let's say, has a direct employee, the manager, and she's expected to work a 40-hour work week. But as we all know, things go wrong in association land. And she's responding to emails at night. People are giving her instructions at night. She's answering questions from unit owners at night, well beyond the 40-hour work week. Now, is the association who is employing that manager going to have problems with wage and overtime, a potential wage and overtime claim?
Interestingly enough, it can happen. So typically we think, oh, this person's a manager, they're definitely exempt from the law. No questions asked, because a lot of times people just hear what the person's title is and they say, okay, that person's exempt. They just make the assumption based on the title. And the law actually says, don't make the assumptions based on title, because often the title can be a misnomer. You have to look at these other things. So what do you have to look at? How much the person's earning. That's a test that has varied over time. It has increased over time. And we call that the salary test. That is probably, in my opinion, the easiest thing to look at, because either they make the salary threshold or they do not. If they make the salary threshold, then we look at the other part of
So
the
what's
analysis.
that threshold before you go on? What would the salary threshold be there?
I believe it's $455 a week, but there's been some discussions over time about what that will ultimately look like, because the salary portion hasn't really kept up with reality. And it's really impacted what I typically think of as lower level management, people who are making just above that threshold and they're working a lot of hours. They have all the responsibilities of what an exempt employee looks like, and they are considered exempt. But when you factor in the number of hours they're working, they're really actually, in a lot of times, making less than the employees who are not exempt, because those individuals are getting time and a half for each of the hours they're working over 40. Those managers are not. And so that segment of the population has always been under the microscope when you see, different administrations, because there's, depending on who's in office, a push sometimes one way or the other to, say too bad, so sad, or to raise the salary. So these individuals are a little bit further removed from what a lot of people will just refer to as the hourly worker.
The Fair Labor Standards Act, do you need a certain minimum number of employees for that act to apply?
Yes, and it's not a lot. It's 2.
Two. Okay.
One of the things that the FLSA looks at is interstate commerce. And any lawyer who's gone to law school, you don't need to be an employment law lawyer. I think we all heard interstate commerce. And I think that was probably the first time I ever heard that word was in law school, or that phrase, I should say. And what does that mean? And over time, it's anything. I mean, if you pick up the phone and you talk to owners in another state about assessments they owe, that impacts interstate commerce.
Or they send in their assessments. We've got so many owners who live elsewhere where their condo unit may be their second home. So clearly we meet that test, hands down.
Yeah, I mean, it's very difficult to, I know locals having a moment, but it's really hard to be local and not impact interstate commerce in some way that would pull you into compliance with the FLSA. So is it possible that you may not need to comply? Sure. I mean, because there's other requirements too. It's not only your business. So an association that doesn't have over a budget of over $500,000 is not engaged in, it's not an enterprise. And so even if they engage in interstate commerce, it may not apply to them. But there's also an individual analysis as well. And hopefully I'm not losing people here talking about like too much legalese. But the point is that an employee may be pulled into it on their own, irrespective of whether or not an association is pulled into it just because of what it is.
My example with the manager, again, let's say we get this wrong. Okay. We've said the manager is exempt. We don't ask her to punch a time clock. Later, the manager goes on to opportunities elsewhere. And after talking to her friend, the labor lawyer, finds out that she has not been paid overtime when she should have been. So what are the penalties then to the employer for having failed to pay an employee overtime?
So what it typically looks like, and I'm glad you brought me back, because sometimes I go off somewhere else. Because what I was saying before, I mean, typically manager, you think they are exempt. Not always, because they may not be paid the salary threshold. So they may not meet the requirement. Sometimes they don't supervise anybody else. Sometimes they don't act independently, so they don't meet the duties requirement. So assuming they talk to a friend, or this woman, in our example, talks to a friend, and maybe that lawyer says, well, let me look at what all's going on here, how much you paid, what do you supervise any employees, and goes through the litany of questions that you would be asking to figure out if this person was improperly classified. The consequence is usually the half-time rate that you owe. So it's only for any overtime hours that this individual has worked. But typically when a person's exempt, they're working a lot more than 40 hours in a week. Like you said, they're taking emails, they're going to meetings, they're doing things on the weekend. And so they're doing a lot of work throughout the week, and they may not be compensated for it. And the worst part is, if you believe that this person was not required to punch in and punch out, so to speak, because you thought they were exempt, the law allows them to guesstimate how many hours they were working. And typically, I've never seen any employee that has filed a claim ever underestimate the number of hours that they work. And the worst part is for the employers, how do you prove otherwise? It's a very difficult task. And the law actually says, there's a saying, suffer or permit to work, which sounds a little weird. And a lot of people may say, well, I don't even know what that means. But basically, it's on you to comply with the law. And if you don't comply, well, beware.
And how many employers are going to keep track of every email that they sent or every email that employee received? So knowing that, is there any downside to making everybody punch a time clock? Why, at least if you're doing that, you don't subject yourself to a possible wage and overtime claim. What's the downside to simply saying, even for people who are in a managerial position, who are supervising other people, is there a downside to just saying we're going to make everybody punch a time clock?
Yeah, well, I certainly appreciate why that may be a knee-jerk reaction. I don't think that employers need to go to that extent. I think that you can do an analysis, make a determination whether people fit one box or the other. But the reason why I wouldn't recommend it is really for a few reasons. One, if you really are exempt, and you work in a work week, you're entitled to pay. I mean, that's why they call it salary. You get the same thing every week, no matter how many hours you work. And that's sort of what I'll call one of the benefits of being exempt, which is different for the hourly. But you never want to be in a position where you give what I would call ammunition to employees to argue that someone who you've properly classified is really non-exempt, because that same argument can be used against you. Well, you make me punch a clock. How could you have thought I was exempt if you were making me do that? So I think the law allows you to treat them different, and you probably should for your own protection. And then if you have questions, you can always reach out to people, phone a friend, phone your labor friend, and ask.
And I'm sure you're going to reinforce the fact that if associations as employers are making these classifications, they should be doing so with the benefit of counsel and a specialist like yourself.
100%. And at a minimum, someone who's well-versed in HR. I work with a lot of HR professionals that do this type of work all the time. They may not be legal experts, so to speak. They may not know the law in and out, but they can make a determination based on the job responsibilities and the salary requirements of whether a person should be classified as exempt or not. So I would say either or, but certainly the worst position to be in is an individual that doesn't know and just makes assumptions, or people who consult Google lawyer. He's related to Dr. Google.
Oh, no. That's like going on WebMD to diagnose yourself. I don't recommend it.
It is. I can't even tell you how many clients I've had that will call before they've done their own investigation, and they tell me, well, I looked on the internet and so I know the test. I'm like, oh, you do? Okay.
Listen,
good.
A lot of these associations have a significant number of employees, and I don't know one yet that has a back office HR department. For some, just as far as we've gotten into this conversation, Jamie, I can imagine for some associations, it's a daunting task to go the direct employee route. So rather than going the direct employee route, hey, let's hire a management company who can then hire our groundskeeper, our valet staff, our security people, our front desk personnel. So what's the benefit of doing that? And are those considered leased employees?
The benefit, and it's a big one, ease. People love easy. I think it was like, isn't there a company that's their slogan, easy, right? If it's easy, that's what you want. So that's the biggest thing. Ease, convenience. You hire a company and they do everything for you. They charge you for it, which is one of the downsides. You will pay more for it. But another perk is that a lot of times you're able to offer benefits that are far better than what you can get on your own. What that means is you're able to attract better talent. So people consider a lot of things when they go to work for a company. Typically, if you can make it more attractive for an employee to join, they're going to. If they're given two options, and one gives better benefits and the pay is otherwise the same, they're probably going to go with the job that gives them better benefits. Not always, but I'd say more often than not. Those are some of the main advantages. One of the advantage that I think as a lawyer, at least practicing in this area, that can sometimes be a disadvantage, and you touched on it, leased employees. Really, and I always ask when employees work with a management company, I always ask to look at the agreement, because I want to see what they say about these individuals. Do you say they are yours? Do you, in essence, own the entirety of the employment responsibilities? Or do you put any on the business that you're contracting with? In other words, does the association have responsibilities about the individuals you hire? If it's clear to me on the face of the agreement that they employ these people, they are not yours. If you no longer use them as your management company, you don't necessarily have a right to these individuals. And in some instances, and I would say a lot, you see these provisions in there that tell the association, you can't hire my people. These are mine. And unless you come to them in the beginning with your own people that they may carve out and say, you can keep those people if the relationship ends, It depends on the agreement whether it's clear or not.
But we could word the agreement where we can wash our hands and say, okay, you know what, if there's issues with regard to a hire or a termination, let's say, that's on the outside employer, not on us as the association who has just hired that outside employer. Is that correct?
It can be. So one of the things I also see is this notion of joint employment, and that's a little different. And the burden is really on you, even though there's sometimes what I'll call a mistaken belief that you are farming out all these responsibilities, and along with it, also relieving yourself of any possible legal consequence that you may have if you violate one of the employment laws. Well, that's, someone else's problem, not ours. And a lot of times it's not. And a lot of PEOs, they don't look at it that way. They really say, well, listen, you are the boots on the ground, so to speak, that these individuals are working there day in, day out. You are providing supervisory responsibilities with respect to these employees. You are dictating how much they pay. You may consult with us, but at the end of the day, we really remove ourselves from the equation if there is a discrimination claim, for example, or a harassment claim. Their attitude is, that's on you, association, not on us, company. That's
so. What's a PEO? I'm going to ask you to explain all the acronyms you use throughout this podcast.
I thought I was going to get away from that. So it's funny. I think when other people talk in code, my eyes glaze over, and I think, what in the world are you talking about? So it's a professional employment organization.
Got it.
PEOs, a lot of time, that's where you're more often hear that term, leased employees. Their job is to provide employees, and they do it on certain terms. And again, one of the benefits of a company like that is that they make your life easy. They hire all the people, they do the background checks, they advertise for the individuals, they help you navigate a lot of the employment potential pitfalls. But a lot of times, like I said, depending on what the agreement says, typically they're putting the burden on you.
Right.
And when I've negotiated these agreements with their attorneys, they're very quick to point out what is our responsibility representing the association versus theirs.
If an association decided to go that route, Jamie, and lease employees, would the board still be in a position to discipline an employee, one of the leased employees, for poor job performance?
A lot of times, yes. Because it is their responsibility under the contract to do the day-to-day operational work. So if you have an employee that should be disciplined, whose responsibility is it? Is it this company in who knows what state, and may not be the state that you're in? And they know the employee because they can go in their database and see who it is, but they're not the ones that are there interfacing with those employees on a day-to-day basis. And the expectation is that you will be responsible for it and you will deal with it.
Okay, now this is getting very complicated. So I am going back to hiring my direct employee. I've thought about leasing, and everything you just said made me think that that's very complicated. So now I'm back to the situation where I'm on a board of directors and I'm in an HOA, and we are looking to hire a few direct employees. What are some must-have provisions in the employment agreement? And I know this is probably going to vary depending on the type of employee we're hiring, but overall, what are some must-haves that should be in that written employment agreement?
Well, I want to take a step back because I think first and foremost, the question is, do you need one?
Okay.
So, and I say that because you can hire an individual by just hiring them. You meet with them, you interview them, you have a need for them, and you say, you know what, I like you, I'll hire you, I'll pay you $15 an hour, show up on Monday and come to work, and we'll go through what your job responsibilities are. Person shows up Monday and is like, you know what, this isn't for me. They leave. They can do that. And there's no contract that you have to worry about. So a lot of employees, most employees are employed without a contract.
So just verbal or a handshake. Is there a downside to that though? What if you made that agreement and the person leaves but says, you promised me something that was not part of that verbal agreement? Does that become an issue because you don't have your understanding in writing?
It can, a lot of times, and it depends on how, sophisticated the employer is. So, for example, usually in an employee handbook, they will say, these are our policies and procedures. This is not a contract. So if a person says, well, I was hired and you promised me this, look, it's in the employee handbook. If the employer violates it, it doesn't give the employee necessarily a right to sue for breach of contract. So it depends on the situation and what you're talking about. Employment agreements are very common with executive and high level. So if you're talking about an association that's a large homeowners association, sometimes, country club homeowner associations that have lots of employees, a lot of times their executives or their directors will have written agreements, really because they insist on it. It's more common with higher level executives to see that because it spells out compensation benefits that may not be available to everybody else. But for most of the lower level employees, you're probably not going to see a written agreement. I think written agreements are good because they protect both sides, and both sides know what they're negotiating from the very beginning. But then when you have a written employment agreement, which is a carve out to employment at will, then you got to look at the agreement, because the law of whatever state you're in may not necessarily apply, because you got to look at what the agreement says as opposed to what the law says.
I see in some of these written employment agreements, Jamie, non-compete provisions for employees that I don't think that they should be bound by these type of provisions. It's my basic understanding that for a non-compete to be really warranted, the employer needs to have invested something in terms of training or conveying privileged and confidential information, something that would hurt the employer if this employee left and took that with him or her. Is that the case?
No, you hit the nail on the head. In my world, I'm looking for the legitimate business interest that you're protecting. And a lot of times employers think they need to protect things that, in my world, you don't need to protect. There's certainly a place for non-competes, and there are states that recognize non-competes. There are states that enforce non-competes. There's some that do not. Florida happens to be a state that does enforce non-competes, but there's still a requirement, even in a state like Florida, that says, I will uphold it. Well, what are you trying to protect? Are you trying to protect a trade secret? Are you trying to protect confidential information? What is it that you are trying to accomplish by doing that? And sometimes it makes sense. For example, I can see it in a world where you have a lot of employees and don't necessarily want to lose those employees or lose business. It may not be a non-compete necessarily, but you may see provisions like, for example, non-solicitation. So if you're a general manager and there is an association with a lot of employees, because some associations do have a lot of them, you want to protect those people. And so if you have a good manager that hires good people, you want to keep the good people, even if your relationship with the general manager, for example, goes south. And so how do you protect that? Well, you need some type of post-employment restriction to do that. How do you do that? You got to put it in writing. So you're going to see it in the agreement.
There's also a length of time component here, isn't it? Isn't there? I think, is 2 years still considered the outermost limit in terms of the reach of a non-compete?
It can be longer, but it would have to be like, for example, an owner of a business. But typically, just an employee, yes, 2 years is really the outlier of what you're looking at in terms of what is reasonable under the law. And then there's also a geographic area. So it can't be everywhere if you don't do business everywhere. It can only be a small geographical area meant to protect your business, as opposed to worldwide, anywhere, especially if you don't have a worldwide business.
So, folks, this takes a little bit of thought, advanced thought when you're creating these agreements, because I have seen some associations, Jamie, where they use the same type of agreement for all their employees. And again, for the head manager, the club manager, that's one thing. For Frank, the maintenance man, I don't know that he needs to be under a 2-year non-compete if he leaves your employ.
I don't know that for Frank, the maintenance man, he should have the same agreement as your general manager. Maybe not even a written agreement.
Listen, if you're going to repurpose a legal document, check first to make sure that you're using it in a way that's not counterproductive.
In fairness, I've seen clients who've said, listen, I used one of the agreements that you gave me in the past, but can you just look over it? And sometimes it can stay the same. But a lot of times it's different because there are different goals that a client is trying to accomplish, and maybe, different terms that need to be included because we're talking about a different kind of employee versus the one in the past.
Or the law could have changed. I've had clients come back and say, that contract you prepared 10 years ago, we've dusted it off. A lot can change. The landscape can change considerably. I think this is a great place to pause our conversation for now. I did want to clarify one thing before we close. Jamie was correct in saying that she thought the minimum exempt salary had been raised from $455 weekly. On January 1st, 2020, Florida changed the weekly salary for exempt employees to $684. Be sure to join Jamie and I for the second part of this discussion, where we examine the less glamorous side of managing employees. You won't want to miss it. Thanks for joining us today. Don't forget to follow us on your favorite podcast platform. Leave a review so more people can take it to the board. And visit takeittotheboard.com for more information.